Good day everyone, especially to you, Dr. Yakibir. I'm Hanna Perocho from BSHM 3A. So in this video, I'm gonna discuss about the chapter 4 that talks about the law on partnership and corporation. Alright, so according to Professor Frank Cavico of Nova Southeastern University, for any partnership to work, the element of trust is essential and is more important than the resources or skills that the partners actually bring into the business. For corporations, good governance and transparency is essential because of public trust. We know that trust is really the most important part of a partnership. Even if partners have skills and money, the business will not succeed without trust. In corporations, being honest and following good business practices is important because of the public trust of the company. So for the learning objectives, we have the differentiate the various kinds of partnerships and corporations and the responsibilities of partners and incorporators. Second is to identify the requirements in the formation and dissolution of partnerships and corporations. So for the topic outline, this is the list of topics that will be covered in this chapter. It includes the laws types, advantages, disadvantages, and processes for partnerships and corporations. First one is the law on partnership. Second is advantage and disadvantages of forming a partnership, classification of partnership, forms of partnership, dissolution and winding up of a partnership, order of liquidation for a general partnership, order of liquidation for a limited partnership, law on corporation, kinds of corporation, advantages and also the disadvantages of a corporate organization, distinction between a partnership and a corporation, dissolution of a corporation, and corporate liquidation. So for the introduction, the tourism industry is a highly competitive field, so business must follow legal rules to operate properly. When starting a tourism business, it is important to have a strong foundation, and that begins with creating a well-structured business organization. Choosing to form a partnership or a corporation is a good option because it provides stability and helps businesses compete in the industry. So in this chapter, this will explain the basics of partnerships and corporations as business structures. In the Philippines, partnerships follow the rules set by Civil Code, while corporations follow the guidelines under Batas Pambansa BLG 68, also known as the Corporation Code of the Philippines. So let's go for the law in partnership. Article 1767, by the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intention of dividing the profits among themselves. So for the discussion of this law, a partnership is an association of two or more persons to carry on as co-owners of a business for profit. The definition of a partnership does not include religious associations, conjugal partnerships, and other similar nature because a partnership is defined by law refers to only associations the purpose of which is to obtain profits to be distributed among the partners. A partnership contract is based on trust and confidence. Hence, the fiduciary relation in a partnership stems from the principle of delectus personae, wherein no one can become a partner in partnership without the consent of all the partners. This means that a partner is a business run by two or more people who share ownership and profits. As I mentioned earlier, the religious groups and other non-business organizations are not considered partnerships under the law. That's why trust is very important in a partnership, and no one can join unless all partners agree. Let's go to the essential requisites of a partnership, and these are an agreement to contribute money, property, industry to a common fund. This is complied. Each one of the partners brings or is obliged to bring something to the partnership. B, that which is brought becomes a common property, and tend to divide the profits among themselves, and this is also complied with if a partnership is established to obtain profits, because profit must be common to all the parties, and profit or loss must be divided among the partners. So here's the advantages of forming a partnership. The first one, it is easy to form, because a partnership does not require many formalities to start. Second is to improve growth possibilities, because more people working together can help the business grow faster. And third one is the freedom from bureaucracy. because there are fewer rules and regulation compared to corporations. For the disadvantages of forming a partnership, the first one is instability, because the partnership can easily end if a partner leaves or dies. Second, difficulty in obtaining large sums of capital, because it is hard to get big investments compared to corporations. Third one is firm is tied to the acts and judgment of one partner as agent, because a bad decision made by one partner can affect the whole business. The fourth one is the difficulty in severing partnership ties, because it can be hard to leave a partnership without affecting the business. So for the classification of the partnership, we have the according to subject matter. The first one is the universal partnership. This partnership is where all of the partners contribute of all their properties to the common fund and speaks of no particular purpose or subject matter, as long as the purpose in forming a partnership is obtained profits and is not contrary to law, morals, public order, and public policy. Because nowadays, seldom if none do you experience business establishment forming a universal partnership. For the second one is the particular partnership. A particular partnership has for its object determinate things, their use of or fruits, or a specific undertaking or the exercise of a profession or vocation. This means that the partners only share certain assets or work on a specific project. So we know that a universal partnership involves sharing everything, while a particular partnership is focused on a specific goal. So for the second classification of partnership is according to liability. The first one is the general partnership, composed of general partners where liabilities extend to their personal properties. The second one is the limited partnership, usually attaches the word LTD or limited at the end of the company name. This partnership is one formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the latter to third persons is limited to their capital contribution. So in a general partnership, all partners share risk, while in a limited partnership, some partners are only responsible for what they invested. So for the third classification of partnership, we have the according to duration. We have the partnership for a fixed term. It is one in which the term of its existence has been agreed upon expressly, as when there is a definite period, or impliedly, as when a particular enterprise or transaction is undertaken. The expiration of the term, thus fixed, or the accomplishment of the particular undertaking specified will cause the automatic dissolution of the partnership. This type of partnership lasts for a specific time or purpose and dissolves once complete. We also have the forms of partnership. A partnership can be in any form, even if not recorded of the Office of the Securities and Exchange Commission, except when it is stipulated, when a movable property or real rights are contributed, in which case there must be a public instrument to which is attached an inventory of immovable properties and signed by the parties. Otherwise, the partnership is void. Also, in case of limited partnership, the parties must sign and swear to a certificate which shall state, among other the names of the partnership, adding the word limited and the character of the business. And then next is the filed for record, the certificate in the Office of the Securities and Exchange Commission. Failure to comply with the foregoing formal requirements will only make the partnership a general partnership. The succeeding pages show a sample each of the article partnership for both as general partnership and a limited partnership. So we have here the sample form of the article of partnership that shows the general partnership. So for the dissolution and winding up of a partnership in the Article 1830, dissolution is caused without violation of the agreement between the partners by the determination of the definite term or particular undertaking specified in the agreement, by the express will of any partner who must act in good faith when no definite term or particular undertaking is specified, by the express will of all the partners who have not assigned their interest or suffered them to be charged for their separate debts, either before or after the termination of any specified term or particular undertaking, by the impulsion of any partner for the business bona fide in accordance with such power inferred by the agreement between the partners. Second, in the contravention of the agreement between the partners, where the circumstances do not permit a dissolution under any other provision of this article, by the express will of any partner at any time. The third one is by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in partnership. Fourth one is when a specific thing a partner had promised to contribute to the partnership perishes before the delivery, in any case by the loss of the thing, when the partner who contributed it having reserved the ownership thereof has only transferred to the partnership the use or enjoyment of the same, but the partnership shall not be dissolved by the loss of the thing when it occurs after the partnership has acquired the ownership thereof. Also, fifth one is by the death of any partner, by the insolvency of any partner or of the partnership, by the civil interdiction of any partner, and by the decree of court under the following article. So for the discussion of law of this, Article 1830, a partnership is a business agreement between two or more people who share responsibilities and profits. However, there are situations when the partnership must end, which is called dissolution. After dissolution, the partnership must go through a process called winding up, where debts are paid, obligations are settled, and any remaining assets are divided among the parties. So, partnership ending process is when a partnership ends. It is called dissolution, and after dissolution, the business must go through winding up, which means paying of debt, settling obligation, dividing any leftover money or property among the parties. So for the next one is according to Article 1830 of the Civil Code of the Philippines, a partnership can be dissolved in different ways. It can happen without violating the agreement, such as when the partnership agreed time period or specific purpose is completed, when a partner lives in a good faith without fixed agreement on duration, when all partners agree to dissolve, or when a partner expelled based on the partnership terms. A partnership can also be dissolved in violation of the agreement, such as when a partner leaves despite an existing commitment or when the business becomes illegal due to changes in law. Other causes include the loss of important asset promised to the partnership, the death of a partnership, insolvency, or a partner being legally restricted from managing affairs. Courts can also dissolve partnership if a partner is insane, unable to fulfill duties, break rules, or if the business is falling or failing. So for the dissolution and winding up of a partnership from Article 1831, on application by or for a partner, the court shall decree a dissolution whenever a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. A partner becomes in any other way incapable of performing his part of the partnership contract. A partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. And also a partner willfully or persistently commits breach of partnership agreement or otherwise so conducts himself in matters relating to the partnership business that is not reasonably practicable to carry on the business in partnership with him. And also the business of the partnership can only be carried on at a loss, and other circumstances render dissolution equitable. On the application of the purchaser of a partner's interest under Article 1813 or 1814, after the termination of the specific term or particular undertaking, at any time the partnership was a partnership at will when the interest was assigned. So for the discussion of the law, so under this Article 1831, a court may also order dissolution in cases where a partner is declared insane, cannot fulfill her responsibilities, engages in misconduct, continuously violates the partnership agreement, or when the business can only operate at a loss. In a limited partnership, where there are general limited partners, the business dissolves if a general partner retires, dies, or becomes insolvent unless the remaining general partners continue the business and update their registration with the Securities and Exchange Commission. If all limited partners die or assign their shares, the partnership also dissolves unless a new limited partner is admitted. Insolvency, which means being unable to pay debts, and civil interdiction, which means losing legal rights due to a court ruling, are also major reasons for dissolution. Misconduct such as drug addiction, fraud, or failure to provide financial records can also lead to court-ordered dissolution. So once a partnership is dissolved, it must be complete the winding up process by paying debts, distributing assets, and officially closing the business. So this explains that courts can end the partnership in any cases of insanity. And after dissolution, the business must follow the winding up process and like paying debts, distributing assets, and officially closing. So for the next one is the order of liquidation for a general partnership. So according to Article 1839, and settling accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. And these are the liabilities of the partnership shall rank in order of payments as follows: those owing to creditors other than the partners, those owing to partners other than for capital and profit, those owing the two partners in respect of capital, and those owing the partners in respect of profits. So for the discussion of this law, Article 1839 of the Civil Code provides the rules on how a general partnership should contribute its remaining assets after dissolution. So this law explains how to divide money and pay debts when a partnership ends. Because dissolution means the legal termination of the partnership due to reasons like withdrawal of a partner, insolvency, or mutual agreement. Because a partnership dissolves when it is officially ends due to reasons such as partner leaving or bankruptcy or an agreement to close the business. However, before the fully closing the partnership, liquidation must take place to ensure that all obligations are settled. And this law, in this law establishes a priority system for payment, ensuring fairness in settling debts and distributing the remaining assets among the partners. So this means that this law creates an order for who gets paid first, making sure the debts are cleared fairly before any money is given to the partners. So for the next one is the order of payment explained. So the law states that liabilities must be paid in the following orders. The first one is debts in external creditors or non-partners. The partnership must pay its debts and third parties such as banks, suppliers, and lenders that are not part of the business. These creditors take priority because they do not have the ownership rights in the partnership. So that's why they must pay first, because they do not own any part of the business and rely on their money being returned. The second one is loans from partners or not capital contributions. If a partner has lent money to the partnership beyond their capital investment, they are treated as creditors and will be paid after external creditors. So it means that if a partner gave extra money as a loan, not as part of the original investment, they must be repaid after external creditors are paid. The third one is the return of capital contributions. Once all debts are paid, the original capital investment of each part is returned. After paying all debts, the money each partner originally invested in the business is given back. And also, if there is not enough money to return the full capital, partners will receive a proportionate amount based on their capital contribution. The fourth one is the distribution of remaining profits. If any funds remain after settling all obligations, this will be divided among the partners based on the agreed profit sharing ratio. And if no profits are left, partners will not receive any beyond their capital. So why is this order important? This order is important because it protects external creditors since they do not own part of the business, and they must be paid first to prevent financial losses. And also it ensures fairness among partners. It prevents internal conflicts by following a standard order of payment, and also to avoid legal issues. If liquidation is not properly followed, lawsuits or disputes can arise between creditors and partners. And here's the sample form of the article of the 1839 that shows the liquidation for a general partnership. So let's go for the order of liquidation for a limited partnership. Article 1863, in settling accounts after dissolution, the liabilities of the partner shall be entitled to payment in the following order. First one is those two creditors in the order of priority as provided by law, except those two limited partners on account of their contributions, and to general partners. Those two limited partners in respect to their share of the profits and other compensation by way of income on their contributions. And also to those two limited partners in respect to the capital of their contribution, those two general partners other than for capital contribution, those two general partners in respect to profits, and those two general partners in respect to capital. So for the discussion of this law, when limited partnership is dissolved, its assets must be contributed in a specific order as provided by Article 1863 of the Civil Code. This means that when a partnership closes, there are legal rules how its remaining money and assets should be shared among those who are owed. This law ensures that debts and obligations are fairly settled because before partners receives their shares. Article 1863 establishes a structured approach to distributing partnership assets after dissolution. It follows a hierarchical order or prioritizing creditors and limited partners before general partners. This law protects financial interests and ensures fairness in business closure, making it essential for business owners, investors, and legal professionals to understand. So the law ensures that liquidation follows a fair, organized process, preventing conflicts among partners and creditors. So this law ensures to protect creditors by ensuring they are paid first, reducing the risk of unpaid debts, prioritize limited partners since they have limited liability and no control over decisions, and also balance risk by making general partners wait longer as they bear more responsibility. If the assets of the partnership are insufficient to pay everyone, the law also states that partners will receive payments in proportion to their capital contribution. So here's the sample form of the Article 1863 that shows the order of liquidation for a limited partnership. So let's go to the law on corporation. So for the law on corporation section 2, corporation defined, a corporation is an artificial being created by operation of law, having the rights of succession and the powers, attributes and properties expressly authorized by law or incident to its existence. So this section 2, the corporation, it shows that a corporation is considered an artificial being because it is a separate legal entity from its owners. It exists independently and has its own rights and responsibilities. This means that it can enter into contracts, own assets, and engage in legal proceedings in its names, separates from its shareholders. So the rights of succession also means that a corporation continues to exist even if its original incorporators, directors, or stockholders change due to death, withdrawal, insolvency, or transfer of shares. This stability allows corporations to continue operations without disruption, ensuring longevity and business continuity. The powers of corporations are limited to those explicitly stated in their charters or granted by law. This means that corporations cannot act beyond the scope defined by their articles of incorporation and the general laws govern them. This limitation protects stakeholders, maintain regulatory compliance, and ensure corporate accountability. The law on corporation establishes the foundation for business entities to operate efficiently while ensuring their responsibilities to stakeholders and society are upheld. So a corporation is like a separate person created by law, which means it can do business, sign contracts, and be taken to court just like a human. It does not end when its owners change, so it can last a long time. However, a corporation can only do what the law and its official documents allow, making sure it follows rules and protects investors and the public. So here's the kinds of corporation. We have the stock corporation. It has the capital stock divided into shares and distributes profits. The second one is the non-stock corporation. So this is not for profit with income not distributed as dividends. And the third one is the corporation de jure. It is the fully compliant with incorporation laws. The fourth one is corporation de facto. It exists despite a flaw in incorporation. The fifth one is public corporation. This is created for government purposes like barangay, city, and municipality. And the sixth one is private corporation. It is formed for private purposes. And the seventh one is the corporation soul. It is managed by a religious denomination. The Illuminati Corporation, it is established for charitable purposes. And for the domestic corporation, it is organized under Philippine laws. And foreign corporation, it is organized under foreign laws. So for the advantages of a corporation, the first one it is that it would be advantaged since it is a strong separate juridical personality, limited liability to it has the strong separate juridical personality, limited liability to investors, free transferability of ownership, centralized management for the board of directors, and professionalism, easier to raise capital. So when it comes to professionalism, corporations are required to follow strict rules, making their operation more formal and professional. And for the centralized management for the board of directors, a group of elected directors runs the company, ensuring that organized decision making. So for the disadvantages of a corporation, it is extensive government regulation. It can also double taxation and also limited activities by charter and laws, since our corporation can only do what is stated in its official registration and what the law allows. So for the distinction between a partnership and corporation partnership, it is created by agreement of parties. Partners have unlimited liability except limited partners. Every partner is an agent unless agreed otherwise. It begins at contract execution. It is also no right of succession. Partners' interest transfer requires consent and also can be dissolved by partners' will. And for the corporation, it is created by law or stockholders. Liability is limited to their shares. It is also managed by board of directors, and it also exists upon SEC issuance of incorporation. certificate has right of succession, and the shares are freely transferable, and it is also can only be dissolved by state consent. So for the steps in creating a corporation, it involves the promotion, incorporation, and formal organization and business commencement. So for the steps in incorporation, we have the draft and execute articles of incorporation. It means that creating and signing the official document that outlines the corporation's purpose, structure, and other important details. And for it also, the second step is the file with Securities and Exchange Commission, Treasurer's affidavit that consists 25% of authorized capital stock subscribed, 25% paid up, and by laws, when it comes to laws, filed with articles of incorporation or within 1 month of SEC certificate issuance. And the third one is pre-filing and publication fees, and these steps involve paying the required fees or filing documents and publishing information about the corporation in a public notice. And the fourth one is the SEC issuance certificate of incorporation. This is after all the documents are filed and fees are paid, the SEC will issue an official certificate that confirms the corporation and legally recognized. So for the contents of Article of Incorporation, and these are the name of corporation, purposes of incorporation, location of principal office, corporate term, names, nationalities, and residences of incorporators, and also for the first of board of directors. And last one is the authorized capital stock, at least 25% subscribed. 25% of subscribed must be paid minimum, paid up capital 5,000 pesos. And here's the sample of the article of corporation. So for the dissolution of a corporation can be dissolved in the following ways. The first one is voluntary dissolution. When it comes to voluntary dissolution, when the corporation files documents with the SEC to close. When no hearing if no creditors are affected, hearing required if creditors are involved. So for the involuntary dissolution, the SEC orders closure due to violations after a complaint, notice, and hearing. The possible reason must be fraud in declared capital, unauthorized activities despite SEC warnings, no operations for 5 years, failure to approve by laws, and serious internal disputes. And for the expiration of corporate term, the corporation automatically closes when its term ends. A corporation can automatically close when the time period for which it was set up expires. This is often set to 50 years, may be extended. Shortening of corporate term. The corporation reduces its lifespan under Section 120 of the Corporation Code. And the fifth one is the failure to start business. If the corporation fails to organize and operate within 2 years of incorporation, it is dissolved. And the sixth one is the legislative dissolution. The government dissolves the corporation through a new law. So let's go to the corporate liquidation. When a corporation is dissolved, it does not immediately cease to exist but continues only to settle its remaining affairs, such as paying debts, distributing assets, and handling legal obligations. Even after the liquidation period ends, former officers and directors of the dissolved corporation may be personally liable for unsettled obligations, including unpaid taxes or financial deficiencies. This structured process ensures that all legal financial responsibilities of a corporation are properly addressed before it fully ceases to exist. So here's the government requirements for starting a business as a partnership or corporation. The first one is registering a business name with the Department of Trade and Industry or DTI, and before the business can legally operate, it must be a registered name. The process of registering a business name depends on whether the business is a partnership or a corporation. For partnership, here's the requirement for the partnership, and also for the corporation. Here's on the screen. It shows the requirements of the submission for corporations and for the partnership. The second one is getting a business permit from the city or municipal mayor. So after registering the business name, you must apply for a mayor's permit or business permit from the local government. And this permit allows your business to operate in a specific area. And these are the barangay clearance and police clearance, certificate of registration from DTI, and payment of fees. And the third one is the registering with the Bureau of Internal Revenue. Every business in the Philippines must be registered with the Bureau of Internal Revenue or BIR to comply with tax regulations. And here's the following on the screen are the following requirements for the BIR registration. And the fourth one, the last one, is registering with the Social Security System or SSS and PhilHealth, because if the business plans to hire employees, it must register with the Social Security System or SSS and PhilHealth in order to provide workers with social benefits like retirement pensions and health insurance. So on the screen, you can see the requirements need of registering in the SSS and PhilHealth. So for the conclusion, the law on partnership and corporation is important because it provides a clear legal framework for businesses to operate, ensuring fairness, accountability, and protection for partners, shareholders, and stakeholders. It defines the rights, responsibilities, and liabilities of individuals in a business, helping to prevent disputes and legal issues. Partnership offer flexibility and shared management, while corporation provide limited liability and easier capital raising, especially in the tourism and hospitality industry, because it provides a legal framework for businesses to operate smoothly, ensuring clear responsibilities, profit sharing, and liability protection. Partnership helps small tourism enterprises like travel agencies and boutique hotels pool resources and expertise, while corporations enable large-scale investment in resorts, airlines, and hotel chains. These legal structures promote businesses' stability, attract investors, and protect stakeholders, ultimately supporting economic growth and services quality in the tourism and hospitality sector. Understanding these laws helps entrepreneurs and business owners choose their right structure, comply with legal requirements, and foster long-term growth and stability in the business world. So that would be all for the Chapter 4 that talks about the law on partnership and corporation. Thank you for listening and goodbye.